All right, y'all, we're going to go ahead and call this call this hearing to order. Do we want to test and see if somebody on the How about this? Miss Travis, I know that you're intending to speak to us today through the computer. Can you talk so that we can see if we can hear you?
Sure. Who were you rooting for last night?
I had no dog in that fight. Okay, we can hear you. So I don't know how, but it's all working. So all right, great, thank you. And I guess you can mute yourself or whatever until um, we call on you. Okay, so we've got four bills. House Bill 74 was Representative Washburn's bill, and we are going to pull that from today and have a conversation and talk about consideration for that one later. Thank you. Welcome to committee. We're down a few committee members right now. Hopefully they'll wander in, but I know that everybody here is not new to this committee, with the exception of Representative Lopez, and so we welcome you to Judiciary Non Civil. As we like to say, this is really truly one of the most exciting committees to be on in the entire General Assembly. What we do in here affects people's lives, perhaps more so than just about any other committee. And so we're very happy to have you. And you're an attorney, right? And what's your practice area? Immigration law. Great. And I have enjoyed chairing this subcommittee for, I guess this is about my fifth year doing this, and I really appreciate a collaborative effort and getting input and really trying to resolve these issues and make sure that we do the best that we can. Very rarely does a bill come before this committee that only has one hearing. In fact, it's usually there's multiple hearings on the bills that we hear in here, because our job at the subcommittee level is to understand what we're doing policy wise and then to perfect it and to make sure that not only is it good policy, but that it is also built to withstand scrutiny across the street in the higher courts. And so we take that very seriously, and so don't anybody take anything personally if it takes a few times before we really kind of start to get to the nuts and bolts of your bill. So that being said, we are going to start with Representative Chairman Petrie's bill, House Bill 168, which is LC 412678. And I will say this, this bill has already been, this bill was heard and vetted by this committee last year. It passed the subcommittee, it passed full committee, and it passed the House of Representatives on the floor. And it was one of the many issues that was not taken back up once we reconvened from the COVID break that we had last year. So this is a bill that has been heavily vetted by this committee, but again, a lot of water has gone under the bridge since then. And so, based on that, Chairman Petrie, if you want to, why don't you walk us through? Pretend like we don't know anything about this and that we haven't already lived this bill from last year. Remind us what it does and remind us of the dialogue that we went through last year. I know that there was some concern about the DAs being able to have access to it, and criminal the prisoners, the defendants not being able to access. And I think that some of that was concerned with informants' names being potentially revealed, and the dangers that come with that. And so if you can kind of walk us through what happened last year on this.
Right. Well, thank you, Mr. Chairman. I'm going to pull this mask off so y'all can hear me. So yes, as you, Mr. Chairman, as you mentioned, this bill, which was House Bill 885, passed last year, did pass the House, and was a casualty of COVID, I guess. So the purpose of this bill, again, just to kind of give you a broad overview again, and we have new members that are here. The goal here is to make sure that when an individual is being considered for parole, that the DA in that community, the chief law enforcement officer of that community, has the opportunity always to weigh in on that. They can't control how the parole board votes in any way, shape, or form, but they can clearly make their case known. To that end, The goal here is to make sure that the records about how an inmate is behaving in prison and has behaved in prison, to make sure that that information is available to those DAs so that they can speak to that issue before an inmate is paroled. Now, I do want to emphasize something. This only relates, very important, to very violent crimes. This circumscribes what are in statute the dangerous sexual offenses, and I have a list of them here if y'all are interested in what they are. Dangerous sexual offenses are a list of 19 crimes, which are the most heinous sexual crimes you can imagine. And it only relates to those dangerous sexual offenses with minors. So it circumscribes that group. And then basically, as you see here on line 21, serious violent felony, the 7 deadly sins. So we're talking about the most violent in our prison system. They are being considered for parole. Our DAs and our victims are notified that they're being considered for parole. And our DAs, only our DAs, not the public, under this bill, under this measure, would have an opportunity to see that record before they are paroled, to be able to make a petition if they choose to about that release. Now, I do want to emphasize this bill, and you see on line 26, accepts medical records, does not include any medical records. And it only includes records after January 31st of 2010. That was an amendment to the bill, or a change that I made for the department, because they now, at that point in time, they went to a different system called the scribe system. And so this is, that was an attempt to make it administratively easy. And then, as you alluded to, Chairman, what we did you'll see at the end of the bill, particularly on lines 47 and 50, we actually added something that doesn't exist today. So currently, this information can be, as you'll see at the beginning, this information can be provided to DAs today, but it is a state secret. It can only be provided if the Commissioner of Corrections declassifies it. So ultimately, the 30,000-foot view, that's what we're changing. We're saying it's not going to just depend on whatever commissioner is in office to declassify this information. This information should not be a state secret from our DAs, from our chief law enforcement officers in our community. It should be available to them. But to get everyone's support with the parole board, with the department, what I did was added lines 47 through 50, which basically say it is already stated it can't be divulged. What 47 to 50 does is go a step further and add something that doesn't exist today. It says that if you do so, it is a misdemeanor. And so what I tried to do was take a balanced approach to try to hear all sides, but to, again, stay focused on my goal. My goal is to protect the community against the release of a violent felon who may not be ready to return to the community. And it seems to me that our DA should have access to that information. When I speak to, common constituents on the street, they're amazed that this information is a state secret in the first place, but it is. And
remind
this
us
bill
what
would
kind
change
of
that.
remind us what kind of records would be sought. Obviously, medical records are not fair game.
Disciplinary records are
so-
what we're looking for. How are they behaving in prison? And so we've had some real high profile cases over the years where, individuals that have been released maybe weren't behaving as well as they should while in prison. And I think that this adds a degree, a little bit of transparency to the parole process, a little more transparency. Again, if you focus and isolate it just on our DAs, let them see that information. And listen, some of them are going to seek it out and some won't. That's up to them.
Mm-hmm.
I mean, the people elect their district attorney, and, that district attorney who is charged with protecting that community, some may seek this information out, some may not, as I understand it. But this will give them the ability to, if they choose to do so.
And if I recall from the committee debate on this bill last year, I remember the quasi painful efforts we came to in reaching the balance that we did on this bill and what this represents, and to verify the significance of how important it is that information obtained by the DAs be kept in confidence.
Yes.
That we've created. If from my recollection, and just tell me if I'm right or wrong here. If the DA were to disseminate that information in a way to the public that, or any way that's not allowed by this statute, that they would be subject to a criminal misdemeanor offense.
Correct. And that would be something that does not exist today. That is correct.
Okay.
To prove that our goal is to allow the information where we say we do. Yes, sir.
Do you have a? How does this work?
I can't flash the button.
Okay.
Yeah, Mr. Chair. Thank you, Mr. Chairman. To the author and maybe, the chair, why aren't these records more available as a sort of standard course? I mean, why is, if someone's doing, hard time in a prison and they're thinking about putting them back out on the street, if this person was in prison, any number of things that can happen, there that is, I think, probative to whether they need to be put back on the street. Why are we limiting only to these? Because there are people that didn't commit these serious sexual offenses, but they're in prison that are really that what got them, what they were convicted on, was something that's a lower level conviction.
Oh, yeah.
That are highly dangerous to go back out on the street. Why are we limited to these circumstances?
Well, I think, again, in the interest of reaching a compromise, what I wanted to do, again, my real concern, and as you know, as long as I've been here, from my first year here, my focus has been on violent crime. And in my community, we have a problem with violence, and so many of our communities. And so I think, in the interest of finding common ground where everybody could agree, and also not making it unwieldy for the department, and by the way, our state prisons are increasingly, because we've done such a good job, I would say, with reforms of our judicial processes. Our prisons every day are harder and harder. So it is increasingly a violent prison system we have. But those individuals, these are the crimes that we could agree on, that were the ones that we really worry about. When you hear about somebody who has, you look at these 19, kidnapping of children and sexual servitude of minors. And these are the things that I can't imagine any person on the street, to your point, man on the street, 100 out of 100 are going to say, yeah, why isn't this available now? So I think it's a good question. But I think, to make the change that I'm trying to do, what I really want to do is focus on those that are most violent and most dangerous and the largest threat to society when they return to that society. And our recidivism rates, as you may know, Representative or Chairman, our recidivism rates are pretty pitiful.
Mr. Chairman, I guess this is just a matter, and I don't know that I was in the center of this when we debated this last year. I might have been elsewhere, but just help me understand. And this is not a leading question. I don't have the answer to this. But obviously well, it's my belief the boards of pardons and paroles, they have access to all this information anyway.
Yes.
So the issue of it going to the DA is what is the sequence of events that makes it important to the DA?
The DA, if there's a case that was of particular note to the community, or a lot of times the victim or victim's family will stay engaged, and I say this as a former assistant DA who experienced this, and there are certain cases that were of such significance that you follow through the pardons and paroles process, and you work hard. Certainly not every case, but there are certain cases you work very hard to achieve a certain result, and it is important to you as a prosecutor, the assistant DA, or the elected DA, to follow up and make sure that you're following what the Board of Pardons and Paroles is. And, there were certainly cases where I submitted letters when I would get notice that somebody was up for parole, where I would submit a letter and give the reasons why I thought that may not be appropriate. And I believe that what this would do, so that's the process. You have the opportunity to interject and advocate as far as why, the Board of Pardons and Paroles can do what they want. Ultimately, it's their decision, but you would have that opportunity as the prosecutor of that case and the representative of the victim in the community, which the crime took place in, to voice the opinion of why, you opine that a parole may not be in the best interest of everybody. And this would, for whatever reason, these come to us as they are, it's classified as a state secret. And so because of that, there's a hurdle in the way that information can be disseminated and used. And so this would essentially allow the DA, if they chose to object or to opine on a parole, to be able to reinforce that decision with, if there's a particularly egregious conduct record that an inmate has while in the Department of Corrections, and it would be able to add, that conduct is relevant as to why or why not somebody should be paroled. Is that correct?
That is, Chairman. And can I add one more thing to
Please.
that to help emphasize the point? Just so everyone here is aware, the Board of Pardons and paroles about 10,000 inmates a year. And so it would seem to me that any commonsensical person would think that because the DAs do have a right to file a written objection, if they choose to, that whether it's victims, whether it's the DA, but it would seem that to call attention, if there's an individual that the community is concerned about, it would seem that the parole board would want to have some input. As the chairman pointed out, they don't have to read it, look at it, do anything, but they are considering 10,000 paroles a year. And so I think that when the community chooses to make a comment, I think it sends a message that this was a heinous act that was committed on the people of this community. And, this is our position.
And in my, speaking from personal experience, in my 5 years of being a prosecutor, there's a handful of times where I engaged the parole board and sent a letter, not something, and it's usually things where the victim family has stayed engaged and been very involved with, or just frankly, there's some cases that just particularly always stand out in your mind, and you have that right to present that information to the parole board. And so I think this is just putting another, I would, call it a small arrow in the quiver, but it's an arrow of the story that they made about themselves with their conduct, how they chose to behave in their time while they were incarcerated. And I don't know how much it moves the needle one way or the other. I mean, frankly,
Mr. Chairman, if we're moving in the direction of more community-based responses and giving people chances, I just think this is probative information people need to know. I'm surprised that it's as narrow as 7 deadly sins and dangerous sexual offenses, but I'm not going to get in the way of the gentleman's bill. I appreciate you bringing it. So.
Ms. Lopez, what number are you? Okay.
Thank you, Mr. Chairman, and thank you so much for giving context. I'm new to this committee, so I appreciate all that background and information. My background is immigration law, and my question is, when I read the bill, and Mr. Chairman alluded to this in the introduction, is how about whether we're going to give this exact information to the inmate? Because as an immigration attorney, when I go to court, I feel most of the time blindsided because I don't have the opportunity to have that information. Are we going to do that to an attorney that's representing that individual?
Yes, ma'am. And there were some questioning on that last year as well. So here's what I would say. This relates directly to the parole process. And so this information that would include things like, how an inmate is behaved, a lot of crimes occur in our prison system. a lot of them, a lot of inappropriate actions, as I have discovered as I've worked on this over many years now. And so one could say that the inmate knows what behaviors he's committed while he's been in prison, but to seek his record, my understanding, I don't know if we have anybody standing by from the department, but the answer to your question is they do not have access to their complete record that we're providing to the DA. That is correct, because this would be provided expressly for the issue of being pardoned or paroled. And so we're trying to provide this to the DAs. I do not believe this information is currently available to the inmate. That is correct.
And one of the things that we discussed last year, this is a different, this is not material that falls under the Brady doctrine and criminal discovery. This is separate from that. And we're talking about, information that is so sensitive that we've literally put a criminal charge on an elected prosecutor for improperly disseminating it. And the concern is, and one of the reasons why as I recall from last year, one of the reasons why this information is considered secretive in the first place is that you have a lot of information from confidential informants that are found in these reports. And the reality of prison life is that, if you're a confidential informant and word gets out that you're a confidential informant, your life could be in danger. I mean, it's not a good place to be. That's not a good status. And that this information is appropriate in one context, but not appropriate in all contexts, and that it's different than a Brady discovery material. And so that was, as I recall from last year, spectrum of how we viewed this through.
Yes, thank you, Mr. Chairman. That is correct. And not only informants, but employees of the prison system.
That's right.
Who might be in those records by name. An individual might, that information would be obviously currently is confidential from them for obvious reasons.
Representative Bodie.
Yeah, thank you, Mr. Chair. And I guess I want to piggyback on what Madam Representative just stated. It would be clear to say in this particular circumstance that if we are putting a misdemeanor offense for elected DA, that we can also have a misdemeanor offense for a criminal defense attorney as well, who was to leak this information or distribute this information illegally. So I think that if we have a standard for one, we definitely can do it for criminal defense attorneys as well. But also because now I have not done a lot of work in parole hearings, I think the defendant can, or the inmate, I'm sorry, or potential parolee can have a lawyer present at some point during that process. I don't think they're statutorily or constitutionally required one, but if a lawyer is involved in the process, I think at least the lawyer should be able to have all the information on the table when they're trying to petition the parole board to give their client a potential parole release. Thank you, Mr. Chair.
I'll go over to Representative McLaurin. And as I like to always say and remind, he is our undocumented member of the committee. He actually is a voting member of the other subcommittee, but I welcome him and his input and discussion on my subcommittee. He just can't vote on anything. So.
Thank you, Mr. Chairman. And as I always like to clarify in response, I prefer ex unofficio and I do pay taxes. First question I've got, Mr. Chairman, and thanks. And I actually want to play some fair ball here and just note that members of this committee from the minority party approved of this measure in its current form in a floor vote. But I also want to note for the record that that was in the interest of validating some compromise that had occurred from the original draft. So my comments now are not meant to be, I think we all have a limit on our attention span during regular session. And so, we do our best, but, given the opportunity to look at this further, I hope that my comments are taken in that spirit. So I'm actually confused to start with about whether the Pardons and Paroles Board has authority to look at inmate records regarding people convicted and sentenced for dangerous sexual offenses. Now, we've been told that they already have the authority to collect that information. And I'm wondering, have we looked at the statutory authority for that? Because the code section I'm looking at is 42.943. It's the same one referenced for written objections. And it's got a list in the A subsection of, the board shall cause to be brought before it, all pertinent information included shall be. Subparagraph 1 refers to all jails, and 2 refers to DOC, but only for serious violent felonies.
Representative, you're on code section 42.536.
I'm on 42.943.
Okay.
Not what you're
You're speaking
modifying.
you're speaking, I got you. Okay,
Right,
I just
because
wanted to
it-
get to the
Yeah,
code
'cause
section.
what-
I got you.
What my understanding of the testimony is that this is information pardons and paroles already has anyway. And so all we're doing is just letting DAs have access to a piece of it so they can formulate their objections. That's my understanding of the bill. Now, without the commissioner's consent. right?
Well, I would say this, whether or not, I think the bill I would have the same passion for the bill, whether pardons and paroles had it or not. But my understanding, and I know they're out in the hall, my understanding from discussions with pardons and paroles is, yes, they do have access to all of the records for an inmate as they consider the parole of that individual. And I don't know, Mr. Chairman, if we could ask them outside, but I think it's a good question.
Is that, and
I
I'm
appreciate
just
the
curious if that's true for all people in custody of DOC, because like I say, the subparagraph here seems specific to, I'll just read it. A report of the conduct of the record of the person serving a sentence for a serious violent felony, as such term is defined, right? Who is in the custody of DOC. So it's not 100% clear to me that pardons and paroles already has that authority. And, the nature of my comment is I would be hesitant to extend to DAs a special privilege that pardons and paroles already doesn't have. And if we're worried about, as the chairman pointed out, disclosure of this information outside of this tightly drawn boundary, that's a problem that would need to be considered if somehow somebody would unknowingly subject themselves to liability for sharing information that is not authorized to be shared with, the board. So I think that would be something to firm
No,
up.
I think it's a good question.
Representative McClellan, what was the code section that you were referencing?
Yeah, the
42
authorized
dash.
42.943, and it's the same one that authorizes written objections, but just in a different subsection. So
And Mr.
subsection A enumerates all of the sources of information that pardons and paroles can
And
contain.
so what you're saying, tell me what you're saying again.
So I'm saying that the subparagraph 2 seems to be specific only to serious violent felony, which is not surprising to me because this current code section we're looking at in this bill contemplates serious violent felonies already. But this bill will add dangerous sexual offenses as a covered type of offense. And so, that seems to be sticky if pardons and paroles doesn't already have that authority.
And we have somebody from pardons and paroles out there.
Chris Barnett is in
Yeah,
the hall.
it-
If would you like me to grab him, Chairman?
Sure. Yeah.
Okay.
Let's,
Let me ask.
while we're on this, and just to let everybody know, I have a hard stop at 6:00. I'm speaking to a Boy Scout troop tonight. So I got to be back in Marietta by 7. So no. No. First, is it the truth? No, that's Rotary. Sorry.
Okay, Mr. Chairman, we have
What number,
Mr. Chris Barnett with
Mr. Barnett?
Board
What
of
number
Pardons
is
and
your
Paroles.
4? Okay, talking to it and see if it works.
Testing.
Okay, were you following outside?
The best I could, yes, sir.
Okay, so the issue has been raised on the cross-reference to code section 42-9-43, which is not in the bill, but I believe there's a cross-reference in line 30, and this deals with the written objection. And this cross-reference code section 42-9-43, it looks like it dictates what information the parole board can consider. And Representative McLaurin has asked that, or he's noted that while the underlying current legislation or current law with this contemplates serious violent felony in this bill as is, which is referenced in paragraph A2 in 42-9-43, we've added dangerous sexual offense to this legislation.
Yes, sir.
And it appears that, and I don't know this for certain, but that from a casual look, that dangerous sexual offense is not currently cross-referenced in 42-9-43. And so my question is does the Board of Pardons and Paroles have the ability to consider, this information about individuals that are incarcerated for dangerous sexual offenses. Obviously, it lists 17-10-6.1 in here, but does the Board of Pardons and Parole have that authority for those that are under incarceration for having committed or been convicted of a dangerous sexual offense?
Yes, sir. I followed a little bit outside. Actually, the State Board of Pardons and Paroles has full access to all DOC records, regardless of the offense that was committed. But we stand by the chairman has worked with us with this bill. We've gotten it to a point where I believe most parties are in agreement with it. The issue was that we constantly got requested for those records, and while we have access to those records, we do not own those records, and therefore we were not able to provide them out. That falls within the Department of Corrections and the commissioner, and I believe that is what's trying to be rectified in this. But the board has complete access to all DOC records, regardless of inmate.
Okay. What I'm going to do now is the only person signed up to speak on this is Ms. Travis. And so, Ms. Travis, can you unmute yourself and you could stay here, Mr. Barnett, in case we need you.
Great, thank you. Members of the committee, I appreciate the opportunity to speak to you by Zoom. I'll start with a little bit of a football analogy since the Super Bowl was last night to tell you that what happens in House Bill 168 is we're creating an uneven playing field for the teams on the field. Prior to 2017, when the parole board was considering serious violent felony cases for parole, the parole board looked at what was before it, including the Department of Corrections records. The DA didn't have a voice or notice. Then with Senate Bill 174 that was passed, it changed the opportunity for both the district attorney and the incarcerated person to be able to submit information. My reference for that is 42943C1. That specifically says, and the board shall also provide the person being considered for parole or conditional release an opportunity to submit information. The problem is that now 168 unlevels the playing field because it only grants access to the Department of Correction records to one side, to the district attorney. Currently, the person who's being considered for parole has no right to see any Department of Correction records to support her release and those that would not. Why should the district attorney be able to get the information without the person being considered having the same information? For example, when an incarcerated person is written up for a disciplinary report, it's our understanding from lawyers who advocate on behalf of those seeking parole that the person does not get a copy of the disciplinary report. And even when those disciplinary reports are dismissed and the person thinks that the issue is behind them, it still is factored in overall institutional conduct and maybe negatively counted in a risk assessment of the person. Let me give you a specific example of how an error can be compounded. One of our members had a client who received a disciplinary report for a gang incident and was listed by the Department of Corrections as a gang member. What had actually occurred was the person had been raped by a gang member as part of that, not the victim, but the other person's initiation to a gang within the system. So the victim was being labeled as a gang member, even though they were not a gang member. It was just an innocent victim. It took years to get this gang designation lifted. The reason that the lawyer was able to get that information was through another case and via subpoena to court. It was not because paroles or the department had declassified the information. But let's just say that information went to the prosecutor. The prosecutor would be using it and the defense would not have any opportunity to say, hey, this is what actually happened, because they don't know what happened. As you can imagine, especially folks that are incarcerated for long periods of time, complete courses while they're in prison, especially those are the kinds of things that they might want to bring to the attention of the parole board, just as the prosecutor may want to bring information about the community. The defense might want to bring attention to the courses that were completed. However, there's no way to get that information because it's held in confidence. When the federal system existed for federal parole, the person that was incarcerated did have access to that information through the Freedom of Information Act. To Representative McLaurin's point, specifically with regard to 42943, if you look at Senate Bill 174, you can see specifically how it was woven in to get to serious violent felonies, and that the opportunity for the district attorney to be able to comment was provided. I think he makes a valid point, because the cross-reference in Chairman Petrie's bill is only is saying, hey, if you're getting information from the department on serious violent felonies or sexually dangerous sexual offenses, the DA should be able to make comment, but the DA doesn't actually literally have the right to make comment under 42943, because that wasn't included in Senate Bill 174. And to tell you the truth, if you all want to include it and make the proper revisions to 42943, we would be supportive of it, as long as you make the changes so that the defense can have access to it. It would really be a fairly simple amendment. If you're looking at the bill, I would point you to line 30, and after code section 42943, you'd put a period, and you'd say, any information provided to such district attorney shall also be provided to the inmate who is under consideration. It's a fairness argument. The other change that would need to be made would be on at the end of line 36, to Representative Bodie's point, to say that if it went to the DA or the inmate, so the specific change would be held in confidence by, insert, such inmate and the district attorney. So we're not asking for any more information than what's going to the district attorney, just the same information that's going to the district attorney, and also being held to keep it in confidence to the extent that it would need to be redacted to protect others. Obviously, that would be something that we would be amenable to. It's, I'm not real good with football because I didn't play that sport, but when you have offense and defense, everybody has a chance to have the ball. The way 168 is written, only the offense gets the ball at all times. Defense never gets to have control.
I would say that some issues have to be looked at in a vacuum. And this is an issue that I think that the way that we normally look at issues with, when we think of discovery information and those type of things, I don't believe that that's the same lens that we look through this information as. And I think that what we resolved last year was that, and I know that this is not something that your organization likes, and I can understand that, but that this information is looked at differently and is treated differently because of that. And so I'm gonna wrap this up pretty quickly here and ask for a motion, but I will call on Representative Bodie. Did you?
Yeah, yes, Mr. Chair. I just had a quick question of Ms. Jill Travis. Thank you so much for your comments, Ms. Travis. One thing I want to ask is what you stated earlier in regards to the process itself. So you're basically telling me, because it sounds like that criminal defense attorneys are available in these particular situations to assist inmates with their parole hearings and to also help them to possibly achieve parole. Is that what you're saying?
That's correct, but they would be hamstrung by virtue of what's in this bill. I mean, they're not entitled. The inmate is not entitled as a matter of law to counsel, but counsel is hired, and there are pro bono services that are offered as well. But the problem is the defense lawyer would not have the same access to information that the prosecution would be arguing.
So at that point in time, the inmate would not have, or the lawyer and the inmate would not have the full benefit of having this documentation to have a I would say, a great presentation to the parole board, because at that point in time, one side will have more information than the other side. So that lawyer will pretty much be hamstrung because they would not have the information that the DA would have in that particular situation. Is that correct?
Yes, yeah, that's correct. And I will say, I mean, I recognize that y'all sometimes get tired of hearing some of our arguments. One of the improvements that was made to this bill was to make it a criminal penalty for the district attorney to release any of the information. That was certainly an improvement to the bill, but it doesn't solve all of the issues in connection to the bill. And there's just no way for the defense to get access to the information. And I think that the gang rape incident is just a perfect example of how that could be inequitable.
And in the same, what's the fee? Okay, in the same vein, the defendant or the convicted who's incarcerated would have certain information that he or she would want to present to the Board of Pardons and Paroles to mitigate their issue, and the district attorney's office prosecutor would not have access or any right to obtain that information on the front end as well. So I think that, again, certain information is treated differently in the context that we're looking at it right now. Let me
Can I just respond to that, Mr. Chairman, to
Sure.
say, I hear what you're saying, but for example, in the gang rape incident, the inmate wouldn't say, oh, hey, don't call me a gang member. You're calling me a gang member. You shouldn't be calling me a gang member. I'm not a gang member, because they don't even know they're being called a gang member. But the prosecutor would know that.
Ms. Lopez, did you, okay, and
I know we want to wrap up, but thank you for Mrs. Travis for that presentation. So what I heard is that, let's say that, would you consider, as the sponsor of this bill, if the downside of allowing the inmate or and perhaps their attorney to have this information would be that there's some informants or some information that you don't want to be disclosed, would you consider having that information redacted, and that would be a compromise?
I would not, and I'll tell you why. Because a lot of effort went in discussion, and I know Mr. Barnett was there as well, with the Department of Corrections, was very concerned about this information being available in such a way that it might harm others in the prison system and, of course, employees of the Department of Corrections, and that they were very concerned about that. So I think I would lose the support. I can't speak for them. I think I would lose the support of the Board of Pardons and Paroles and of the Department of Corrections if we were to do that. To the broader point, I would say this: remember, parole is a privilege. It is not a right. And what I'm simply asking is this: that person that is most dedicated to protecting the people in a community, we want them to have an opportunity to discover how an individual is behaving in prison before they're released, and to make a comment, to if they choose to file a written objection if they choose to that end, if they are fearful that individual. Remember, a jury of one's peers has already convicted these individuals to a sentence that is now being considered truncated by the Board of Pardons and Paroles. So the people that DA is elected by expected that individual to be in prison for X number of years. Now we're truncating that. It seems to me that the people's voice, they should have someone to speak for them, because there's a victim, at least one victim in that community, who suffered horribly because we've circumscribed the crimes. And so, no, I would not support that. But thank you, and I appreciate the question, and I certainly understand the issue.
Thank you. And I believe the victim and both the DAs under the current law would be allowed to present their objections and their comments on the process.
Representative Sains, hang on, are you number 8? Yeah, I don't know why it's, try now. Try now. It's not working. Grab Setzler's.
7.
Is it working?
I'd like to make, I'd like to make a motion to pass House Bill 168 LC 412678 to full committee.
So there's a motion to pass this LC. Is there a second? There's a motion and a second. Are there any amendments? Okay, who? Yes, Chairman Setzler.
Just in the spirit, I mean, to the author, this subcommittee, where we're just talking about stuff, and I just appreciate the chair's ability. From my vantage point, I mean, this is just me speaking as a member as I listen to this. I'm concerned with 2 things. I guess I don't call it both sides of the question. I believe that every single offense ought to be available to prosecution. And I personally believe that every single offense ought to be redacted and made available to defense so that somebody that's things are being said against them, they can speak to it. They can have it addressed. No, that's not my bill. I could bring my own bill that says that. So I'm not trying to hijack your bill. I'm just saying, I'm concerned this only happens for 7 deadly sins and dangerous sexual offenses. I think every single offense that comes out ought to be made available. And because you can have people on low-level offenses, they pled to a lower offense, the DA ought to know about it. But I think at the same time, from a due process perspective, I know it's a privilege, but people not knowing what's being, I mean, what Ms. Travis said to me was persuasive, but I also believe that this issue, it ought to be everything, not just these few. I'm not trying to broker some deal here. I'm hesitant to try to broker a deal. But it is persuasive to me that if there's a commitment to redacting information that could keep individual members of the prisons or employees of the prison system from being exposed, those kinds of things, and any other number of things that would need to be raised as a concern to this committee that I've not thought about. I don't have the conceit that I've thought through all those options. And that is, and that the criminal defense attorney has, faces the same criminal penalties as a DA might. There's not many things we give DAs criminal penalties for. This is pretty unusual. But you think about that balance. You think about this interest to redact. I mean, if I were sitting back or we're sitting around over a beer talking about this bill, I'd say we need to make it every single offense, but that you give defense the information. I don't know if that's something that's even open for consideration, but that's, to me, seems in the direction of balance, because I'm concerned there's people being let out of the system that we don't have adequate information about. They've been bad actors in the system. We need to know about what they've done. So I've got both of those concerns.
I think Representative, what I believe, there's been a lot of good comments on both sides. I appreciate all of them. My goal is to just make it better. I think I've made clear what my goal is. I will say this, I do believe the volume with the parole board here, I think if this information were made available to DAs for all considered parolees, the volume of those individuals would probably be such that I don't think DAs would have time to even think about looking at it. Am I right, Chris? Or is that, I mean, it would be an enormous amount of information. But again, I was, early on, I didn't realize the degree to which the department said that redacting this information is an enormous process. They really did. And what worries me to Representative Lopez's question is it also may not always be complete. So if there is information that's redacted, but something is missed, the department led me to understand that there could be serious consequences to that. And so I think that, which is why I agreed, and with others' testimony, to try to make sure we added the protection with the misdemeanor to make sure nobody gets it, which is a provision that doesn't exist today. So I heard that, and I want you to know I hear you. But again, that's a real concern that I think we'd lose support on the other side if we were to do that for that reason. But I understand your point and agree.
Okay, so I believe that Representative Lopez was going to propose an amendment.
Yes, so thank you so much for continue conversation. It's always good to have a conversation on both sides. And to me, going back to my very
No, hang
first
on.
question.
We're in a amendment proposition. So if
Okay.
you have an
Oh,
amendment, propose
okay.
it, and then we'll have discussion on that.
Absolutely. So I would move forward with proposing an amendment to include or allowing the inmate to have the same information as we are proposing the DAs have.
Do you have specific language to present to us right now?
I don't.
Okay. Are there any other amendments?
Yes.
Okay.
I have an amendment. I think to line up with what Ms. Jill Travis stated, I think, and I want to be clear, I think on line 37 is where we need to insert the word inmate, such inmate and the district attorney. And I think she also stated that in line, I want to go back in line 33, I think we also have to insert the word inmate and the district attorney right before the word district attorney. And that way we will basically capture both the DA and the inmate and or their counsel if they have one with the information.
So the amendment as proposed, we're not discussing it right now. The amendment as proposed is to submit the word on line 33
Yes,
in front of district. It would read request for such records from the inmate and the district attorney.
yes.
And then in the beginning of line 37, in front of the, we would insert the inmate and.
The district attorney. Yes, sir. Yes, Mr. Chair.
Okay, so there's an amendment that has been proposed. Do we need that scripted out anymore? Or are you good? Okay. All right. Is there any discussion on the amendment that is proposed by Representative Bodie? Is there any discussion? Okay, so seeing that there's an amendment on the table, all those in favor of the Bodie amendment vote by saying aye. All opposed, vote nay. Okay, the nays have it and the amendment fails. Are there any other amendments to this legislation?
Mr. Chair, I'm sorry, point of order.
Do you have an amendment?
No, I just want to make sure, can we call the vote? I want to make sure we have the vote count. I didn't get
It was clear that there were four. There's not a question in my mind about the number of no's, but you know what? I'm feeling kind today, although we are running over and not going to get through all these bills. Everyone who voted yes, please raise your hand. Who voted yes in favor of the Bodie amendment? That's accounted two, and all those who voted no. That would be four. So I was correct in what I thought I heard.
Thank you, Mr. Chair.
Okay, so there are no more amendments. All those in favor of the passage of LC 412678 vote by stating aye. All opposed?
No.
Okay, so again, according to my ears, I think that it was clear that the bill passed, and this bill passes on to full committee. So thank you, Chairman Petrie.
Thank you, Chairman, and to all the members for your great comments.
Representative Belton, Chairman Belton, if you want to come up. We're going to now be moving on to House Bill 288. Do you have anybody that will be testifying with you, or?
No, sir, but I do believe there's a few people who want to speak on the bill.
Okay. Okay,
Thank you for your time.
so why don't you tell us about House Bill 288?
Well, I want you to say that this is my very favorite committee, and that my first bill was in this committee, actually. And actually, Ms. Travis wrote that legislation about teen pornography, actually. So I appreciate the time to go to again. Y'all may not remember, but this about a year ago, the guy named Pete Mallory, this is why I brought this to you. This man was convicted of a 60 different count conviction of 26,000 files of child pornography. He was sentenced for 1,000 years and got off and was paroled after 7 years and 5 months. So I got blew up about this for a lot of my people back home, and I'd worked with the pardon, the Board of Parole, about how we could improve this language. So I bring before you Lima Charlie 280121 substitute. The number, page 2 is where really the meat of the bill is. It's saying that everyone before July 1st of 2021, we're not going to touch. So this is only for new convictions. But for everyone from after July 1st of 2021, if you are convicted of a sentence from 21 to 50 years, you should serve at least 7 years before you come to parole. If you're convicted from 51 years to 75 years, you have to serve 14 years. And if you were sentenced to 76 years or more, you'd have to serve at least 30 years before you're up for parole. I've talked to about a dozen judges about this. I've talked to several district attorneys. I've talked to the prosecutor's counsel and the Board of Paroles. And I'm not going to speak for them about what exactly they said, but in general, certainly the judges and the district attorneys said that they welcome this legislation because they felt like it would bring equitable time to what they were seeing, and really is a truth in sentencing issue. What I hear is that from judges don't really know, when they put out in the sentence, they have no idea what the parole board is going to do with this sentence, because the parole board may be very lenient or they may not. Well, here we have a more of a standardized level the playing field way to look at this without infringing on the rights of the Board of Parole. So that essentially is the bill. You may ask, well, how many people is it we're talking about here? As Chairman Petrie said, we parole about 10,000 people a year, but people who are serving over, like 40 years or so, that's only a universe of about 300 offenders right now. So that's 0.03% of the inmates that we have. And of course, at the very beginning, we're talking about 0 people because no one has been, is under this law, if it was to pass before July 21st. And the other, July 1st of 2020, the other thing I'd say is that this would, I believe, judges would be able to make smaller sentences, knowing that if they, sentence someone above 21 years, that they'd have to serve a whole 7 years. So that's the bill, and I'd answer any questions.
Number 6. Who is that? Okay. Representative McLaurin.
Thanks, Mr. Chairman, and good to see you, Chairman Belton. Glad to catch up with you this morning. Appreciate the last comment you just made about trying to incent judges to possibly give lower sentences, and I hope that would be the effect. I have a couple issues I'd like to raise. One is a technical issue. Am I right that your intention is to leave no gaps between these different ranges of sentences that have different treatment or effect within the legislation? Like, for example, on line 20, you have a certain treatment for 21 to 50 years, and on line 23 of 51 to 75. Am I right that you need to leave no gaps between those ranges?
That's correct.
Okay. My worry is that the way it reads right now, it leaves a 12-month gap that this statute would have no application to from 50 to 51. And also, if you look at lines 23 and 25, from 75 to 76. So my read of the plain language is that if you were sentenced to 75 and a half years, this code section just wouldn't apply to you at all.
I think that, and I know that Ms. Travis is signed up to speak on that, but I think that she has a different point of view on that I believe from my conversation with her that she believes the way that it's worded here is the correct way. And when the time comes, how about we let her address
Sure, that's
that?
fine. Well, it's not typically my posture to make a point like that, but that seems to be my reading of it. So the second issue I've got, and this is maybe a broader thematic discussion, is, we're talking about a constitutional board, right? The Pardons and Parole Board that we have vested constitutionally, not just statutorily, with discretion to make decisions about individual cases. And the sponsor, and I think other members in support, have been pretty transparent that this particular initiative seems to be driven by one case. where the Pardons and Parole Board exercises its discretion and in a way that members of this body disagreed with. But what we're looking at is a proposal to change outcomes for potentially, as you said, and I know that this is prospective only, but in terms of the numbers, 300 people serving very severe sentences and up to 10,000 a year who are paroled, in some other range. So I guess my question, and this is one I'd really propose for the whole committee to consider, hopefully in a little bit of depth, is why we would take away discretion in a systematic way for potentially thousands of cases based on one use of discretion by the board that some members disagree with.
Do you want to?
Again, the board, I'm not going to speak for the board exactly, but I had a lot of discussions with this, and they helped write the bill. So I think they don't feel the same, that this is a real problem for them. I think they would like a little bit of, this is my words, not theirs, but a higher authority that they say, yeah, the judge, he gave the person 20 years. That means we can parole him in 6, but if he gave him 21 years, then the judge really thought it was whatever crime was committed is a lot bigger deal. So they, I think, would say, from my opinion, the more you standardize things, the more you're leveling the playing field, as Ms. Travis talked about.
This doesn't happen every day, but Representative McLaurin and I, sometimes we agree on things, right? I think that from my perspective, changing the entire system based on, I try to be consistent, and I say this a lot. We deal with outliers individually, but we should legislate to the majority of circumstances and issues that come about. And there undoubtedly was an outlier that whatever the reasons are for that decision, those reasons are there, and a lot of people in the community disagreed with that. But I do think that we have to be very cautious when we're looking at changing the entire way that we approach parole because of one outlier. I have a couple, and I will say this, where I want to make, I don't know if I misunderstood anyone, but it seemed like a few minutes ago, somebody said something to the effect of trying to incentivize lower sentences. And I think that's the antithesis of what the job of a judge that oversees a trial or has to make a sentencing decision in a non-negotiated plea. They're tasked with sentencing accordingly to the factors that are before them. And gosh, I'm not saying that judges sentence perfectly, but I hope that we don't, to phrase it as trying to incentivize lower sentences is really worrisome to me. And I don't know if I misunderstood that. I think that my hope is that a judge will sentence appropriately in every case that they have. But do we have, and I'm unclear about this. I know that the number 300 has been thrown around. I've heard that number. Where does that number come from? Is that because I believe that there are more than 300 inmates in Georgia that are under sentence for greater than 21 years. Is that
that number came from the Board of Paroles. What you can ask them specifically where they got the number, but my understanding was about people who incarcerated persons for more than 40 years or so.
For more than 40?
Yeah.
Okay. And do you want to be available? Have a seat. And Mr. Barnett, is the how many individuals in Georgia do we know? And if we don't know, we don't know. How many individuals in Georgia are under sentence for more than 21 years right now?
We do not know that information at this time.
Okay.
What the chairman is referencing, last year after this particular case that concerned a number of the public. We looked into the information to see how many individuals were actually serving a sentence of more than 45 years, excluding life sentences, life without parole and all that, but just who was serving a sentence counted together of more than 45 years. And it was a little more than 300 at that time. But that is a huge gap between 21 years
That's
and
right, yeah.
45 years. And you're going to have that number significantly higher. I would really defer that question to the Department of Corrections. They're the housing.
And so with the, the way that I understand this legislation is that it would in some cases double the amount of time where a person is eligible for, if a person is eligible for parole at, 3 years, 3.5 years, that under this, that eligibility would in some cases double as far as the amount of time. And so that would essentially require, essentially it would be in effect a longer sentence. And obviously we're not in Ways and Means right now, but is there, this bill stands to have a fiscal impact that I think we would have to get comfortable with before we can even, because if we're talking about, potentially inmates having to serve longer of their sentence before they're eligible for parole, then there's a cost associated with that. And obviously parole is a gray area of, it's not a right, it's a privilege, as was stated earlier. But I think that the financial piece of this would be something that we would have to look at in consideration. What are your thoughts, Mr. Barnett, on that?
Absolutely. Certainly there's going to be a cost associated with taking someone that the board could look at 7 years and increasing that to 30 years. So you're increasing that incarceration by inmate by potentially 23 years before they're ever looked at for the first time by the board. So at roughly 60, and again, please, I do not want to speak for the Department of Corrections, but if the
Mr. Throw, do you want to have a seat maybe over here? Pull that mic. Is that number 5?
Yes.
Please introduce yourself.
Hey, my name is Rob Throw. I'm with the Department of Corrections.
We've obviously been talking about you a lot.
Sure.
So what are your thoughts on the things that we've talked about as it relates to DOC?
So when this bill was introduced, we've been trying to run the numbers, and rough estimate, I know we hadn't been on we hadn't communicated about the numbers we've had. I think they're close. I mean, they're the ones we pulled this morning, and we still need to go refine our search. The ones we had this morning, I think those in our custody that are parole eligible with a sentence of 75 or greater was around 160. Those that have a sentence from 50 to 74 years was around 590. I had to go back and check. And then those that are 25 to 49, that would be parole eligible, I think was around the 9,900 range. So roughly around 10,200.
And so and I don't know if y'all have had the opportunity legally to analyze this legislation, but if you have, and if you can speak to it, and if you can't, then don't worry about it because I'm putting you on the spot. But does Department of Corrections have any analysis of this that would seem to indicate that there would indeed be a longer period before current parole eligibility versus eligibility under this? Would that indeed lengthen the amount of time that someone would serve before they would be eligible for parole?
Yeah, and in fairness, I think we have been trying to quantify that number, but we just got back the raw numbers for this morning, and so anything that I threw out would be merely speculative, and so I don't want to throw out a rough number and then be totally wrong the next time we come to committee. So in short, no, we really haven't had a chance to analyze those numbers and the fiscal impact that it would have on the department. Just reading the language, assuming that it would. But again, I can't speak because it'd be kind of speculative for those numbers.
What, if I could just have both of y'all stay here, because we may need you.
Yes, sir.
So Chairman Setzler. It doesn't look like that's working.
Are we on one?
Yeah, we are.
I'll go back to 7. I moved over here for the better mic. It's working. How about that? Just gotta jiggle it, right?
Okay.
To the author, appreciate your engagement in the question. To the department, actually, I'll address this to pardons and paroles. I looked at other. You think about serious cases. You've got this pornography thing that's happening, that you've got a bunch of photos that were kind of added up, and it was kind of charged that way. So they're having the stacking effect. But you look at the individual offenses that carry more than 20. Child molestation is a 5 to 20. Aggravated child molestation is 25 or more. So you think about an aggravated child molestation case, and I'm in no way diminishing someone who's engaged in pornography, but is engaged in maintaining a large volume of pornography versus a smaller volume of pornography. I don't know that 2,000 or 20,000 pornographic pictures is that different in essence. If you think about this, and I don't know all the facts of the case, but I think about, there's a person engaged in pornography and there's a penalty for that. Is it fair to assume that when the board was looking at this case, they viewed the particular sentencing structure that was perhaps unique to this case, or less commonly applied, but had been applied to this case? They looked at it through the lens of other pornography kinds of convictions, and they tried to handle the parole considerations more consistent with pornography as opposed to 1,000-year sentences. Is that the lens through which they were looking at it?
Again, I would say because we have 5 voting board members that look at this case individually and cast their own decisions based on the information presented, it'd be difficult for me to answer how they reached the decision they did. However, they did have access to all of it, including the sentencing and what similar situated individuals would be charged, convicted, and sentenced to. And certainly that influenced their decision one way or the other.
I asked the question because are there cases, do you know of any cases, or do you know any number of cases of, say, aggravated child molestation, which is 25, I believe it's 25 to life. Do you know of aggravated child molestation cases that would have been considered and granted parole in the duration that this pornography case would have actually brought?
Yeah, aggravated child molestation is not parole eligible, so they'd have to serve every day of the sentence that they were given.
Okay, so what I'm getting at is, we've got a couple structures. We have mandatory minimum sentencing. This is your, and we've got this rubric that, and because of that, the legislature's talked about what's parole eligible and what's not. So we're in a place where things that I guess my approach to this is things that carry more than 20 years of minimum sentence and are sentenced that way aren't parole eligible, and we have ways to arrange and make sure that's the case because the nature of the case.
Yes, sir.
If you think about the nature of pornography, I don't know, and I haven't read the facts of the case, how many incidences of pornography were charged in this, but I guess that they stacked as they brought the charges. It seems to me that we're trying to get at this issue of number of years as it relates to eligibility for parole, when our system more typically looks at a specific offense, because we're not talking about multiple offenses. We're talking about, aggravated child molestation or 2 counts of aggravated child molestation, because of the nature of the offense having a longer sentence. It seems like the board would normally look at it through the lens of the offense, not the years itself. And is the question I think before the committee is the years of the sentence itself the most important consideration, or is it the nature of the offense that got them there? And am I right at trying to draw that distinction?
I think you're right. If I may, Chairman. So one of the duties and responsibilities of the board is to bring equity among sentencing of similar situated individuals across the state. So an individual with a similar background, a similar criminal offense, a similar would serve a similar amount of time, all things being equal.
Yeah.
Right? And that is where our guideline system comes into effect. It says this offense is sentenced at this level as an average of judges, right, across the state. And the board historically has voted at this level for this level of offense. So when we see similar situated individuals, that is what we will produce to the board to focus on the offense as it relates to others that have committed similar offenses in similar situations.
And the board and the courts have a equal application of justice interest in doing that, correct?
That is correct. Yes, sir.
So there's a I mean, I don't want to throw the term there. There's almost an equal protection, it's almost an equal application of justice interest in doing that. And it's not rigid, but there's a considerations. My concern is, and I'm friendly to the issue the gentleman brings, but is the term of sentence is it so ironclad and so consistent, so internally consistent that it can drive pardons and paroles decisions? Or does the Board of Pardons and Paroles do well to look at the nature of the offense, weigh that against other things, and maintain the flexibility to apply their judgment that way? I mean, it's, you know, we as a legislature have taken some discretion away from judges with mandatory minimum sentencing. I think we've seen that in certain cases that's appropriate. Others might disagree. I don't know that if we ever delved into the circumstance of putting limitations on the boards of pardons and paroles in this way before. Are there other cases?
I think the last time and the only time to my knowledge is the introduction of the 7 deadly sins.
Okay.
And to make them ineligible. And of course, that was a constitutional question.
So there is an issue of eligibility for parole,
Yeah.
but we've never delved into this question of actual terms of parole in terms of the durations. That's not something the legislature's delved into before.
That's correct. It's guided by statute, and I can't remember at what point those statutes came online. But
And again, I'm not shooting, I'm just trying to understand. I don't know that we've done this, but I don't recall having done this. This structure is a way of getting at this issue.
Yeah.
Okay, thanks.
What I'm going to do is ask Miss Travis, who signed up to speak on this. Miss Travis, if you want to give us your thoughts.
Thank you, Mr. Chairman. You all have heard the expression over and over again, bad facts make bad law. The 1,000-year sentence imposed for Mr. Mallory was an emotionally charged set of nonviolent offenses, yet this bill completely removes the discretion of the board in all cases. Obviously, the primary consideration of anyone who's serving a sentence is the public safety risk, which is a metric that the board takes into consideration carefully and conservatively. In making their decisions, equity and punishment is something that they strive for, taking into account geographic disparities, age, risk to offend, just the factors that Mr. Barnett was talking to. In fact, their metrics are evidence-based and subject to review and revision approximately every 5 years, and I think it's about to undergo one of those reviews at this moment. So despite the atmospherics around the 1,000-year sentence case, this aspect of parole consideration is actually not broken. The first thing that I would mention to the committee is I know that this committee has a long history of considering whether a law you recommend could be successfully constitutionally challenged. I will tell you, it is subject to challenge and it will be challenged if passed. House Bill 288 violates the Georgia Constitution, Article 4, Paragraph 2. Let me say that again. Article 2, Section 2, Paragraph 2. The only ability, and Mr. Barnett touched on this slightly by talking about when the Constitution was amended having to do with the 7 deadlies. That was in a measure that went before the voters in 1994. The problem with 288 is the only discretion that the legislature has is to deal with parole on second offenses or consecutive life sentences. So in 1994, when the legislature proposed a constitutional amendment, it was passed by the voters. It was narrowly tailored how you all could restrict the broad powers given to the parole board. So to change the law now as set forth in 288, you'd have to amend the Constitution in my viewpoint. I think that the other thing that comes about with your consideration of this bill is a number of unintended consequences that I have a very much affection for Chairman Belton, and I hate to speak against a bill that he's proposing, but I do that because I think that you take your job seriously. What you're doing with this bill is this completely removes any distinction between a violent offender and a non-violent offender. We can see that the bill, that's one issue. Let me give you a second one. We can see that the bill makes an exception. If you look at, well, I'm not looking at the sub because I don't have it, but it was around line 19 where it mentions except as provided in 1710.7, which is the recidivist punishment. So we do have, the legislature does have leniency built in for certain drug-related crimes that can carry very high sentences. So imagine you have two men that are both charged with possession of a controlled substances. Both are given a 55-year sentence. Under House Bill 288, the man with 3 priors and as a recidivist is going to be eligible for parole at 6 years. But the first offender is going to be eligible after 14 years. I don't think that is a result that you are intending to make. Thirdly, another unintended consequence would be when two people are charged with this, convicted of the same crime with the same facts, same criminal history, but they're sentenced in different jurisdictions. So one judge gives a sentence of 18 years and one judge gives a sentence of 49 years. The one that got the 18-year sentence would be eligible after serving a third for parole, so 6 years. The man that got the 49 sentence would have to serve 7 years under this bill. And then also, let's just look at a 1-year difference in sentence. One person got a sentence of 50 years and one person got a sentence of 51 years. Their parole eligibility would vary, according to this, by 8 years. Another issue that you should consider is the education and rehabilitation is, of course, at the heart of all of those things we want to consider when we look at people going to prison and how they can improve themselves, and hopefully they'll be a more contributing member of society when they return. The Department of Corrections limits the types of certain classes that can be given to inmates based on their tentative parole month, because there's limited spacing for those classes, and they want to give the education to those people closer to the door. So this bill is going to limit access to programming that I think can all agree would be productive for the inmate as well as the public safety objectives. Of course, you all know that literature shows that not holding people in prison longer than necessary is an edict that should be followed, because the longer they're in, the more damage is done. I mean, of course, young inmates, mature inmates do improve. Some work very hard in the prison to improve themselves. And none of that can be realized with this one-size-fits-all kind of bill. And of course, longer sentences are going to increase the cost for Department of Corrections over time. Older inmates have additional medical costs. And I think we're right on point with wanting to be cautious about looking at the fiscal considerations. In particular, in the Mallory case, we understand the frustration that surrounds the facts and circumstance, but we don't think that the reaction should be that to remove all discretion. In fact, if you look at the Mallory case and you understand that in the fall of this year, the Supreme Court decided a case called Edvilson, EDVALSON, which would have opened the door to Mr. Mallory being resentenced. And if successful, he could have been serving a sentence of something closer to 25 years. So that's another consideration when you just bad facts make bad laws. One of the things that I think Chairman Setzler was pointing at is a distinction that we'll call doers versus viewers. Doing an act versus viewing an act. So is possession of images that garners a 1,000-year sentence the same as raping and murdering a child? I mean, because raping and murdering a child, you're going to be parole eligible at 30 years, and viewing images, you'd be eligible for 30 years under a 1,000-year sentence under this consideration. A second conviction for child molestation carries a mandatory 10-year sentence, which an aggravated child molestation carries 25. Both of those folks are going to get out at 10 or at 25 years, but the viewer, Mr. Mallory, would stay in longer. To me, that doesn't, to us, it just doesn't make sense. So because we think that the discretion is completely removed by this bill, even if the charges are identical, circumstances can vary. As you know, advocacy for a client is different across the state. Judges in different counties impose radically different sentences for the same offense, and having media in the courtroom can also affect the time of sentence that's imposed. House Bill 288 is unconstitutional. It prevents meaningful consideration of the person and the offense, and it fails to account for disparity in sentences in different counties. For that reason, we'd ask that you take a better look at this one.
Thank you, Ms. Travis. And what I'm going to do, Chairman Belton, is we're going to hold this, and I think that there's some things that have got to be looked into, especially potential constitutional issues. And I think we need to work with legislative counsel on that. And I'll be happy to offer what help I can. And so I think we've got some things to look at with this. And so with that, I'm going to hold on this and not make any movement today. And so now I'm going to call. Thank you for your time.
Yeah, thank you for the discussion. I appreciate it.
And I think that neither of you have any other bill that would require you to be here today, right? Okay, so y'all can get out of here. Representative Gaines, I'm going to call House Bill 231, which do we have a sub on that? Or is that, am I confusing that? All right, so we're working on LC 412822. Can we have Ms. Grist? Do you want Ms. Grist to come in and sit with you?
Sure.
Why don't we go ahead and do that? I know that there's a couple of other folks that,
Yeah, there should be a few folks online as well.
if we could get Ms. Grist in here. You could just have a seat right there.
Okay, can do.
If it's okay, Representative Nguyen has been
Sure.
helping us out a lot as well.
Great.
Well, I'll be really brief and just kind of introducing.
Yeah, actually, don't be brief. I want you to walk us through. I mean, I want y'all to walk
I'll
us
be
through in
brief and then
detail. Sure.
Let others, if that's
Okay.
okay. I just want to present the issue and then let the other folks who are with us kind of walk through the language and some
Great.
of those other matters. But basically, this legislation would be a significant step forward in our efforts against domestic violence in Georgia. Over the last several months, we've worked with advocates. In particular, I want to thank Chairman Mandy Ballinger and Representative B. Nguyen for their work on this legislation. Georgia is one of only 3 states that does not extend temporary protective order protections to victims of dating violence. Our current family violence law denies access to potentially life-saving relief to some of the most at-risk victims of relationship violence, including those who are pregnant, teens, and young adults in dating relationships. This legislation would extend safety to victims who experience abuse by current or former dating partners, and it would update the definition of family violence related to TPOs granted by superior courts. Temporary protective orders are tools for victims seeking safety from abuse and are also an effective mechanism for abuser accountability. This bill will ensure those in dating relationships and potentially some of the most vulnerable in our state have access to this life-saving relief. States that have proactively included dating partners in their protections under a TPO have seen 11% reduction on the total rate of intimate partner homicide. This bill is supported by the Georgia Commission on Family Violence, and we've included a letter of support from them in your folder. We've also included a letter of support from Georgia Life Alliance, and I believe Joshua Edmonds will be testifying a little bit later as well. But again, want to kind of turn this over to the folks who have who do this on a daily basis. Jamie Borman is online, I believe, and she's a deputy director at the Crisis Line and Safe House of Central Georgia. Judge Alex Manning, who's a Fulton County magistrate judge, I believe is also online, as is Vicki Kimbrell with Georgia Legal Services, and then Solicitor General here with us this afternoon as well. So we're happy to go in any order that Chairman would like to go in.
Why don't, Ms. Gris, can you walk us through the mechanics there? Are you the person that is best situated to walk us through the mechanics? I mean, this is a very mechanical bill. We're creating a new definition. We are creating findings for a court on a TPM. It's very mechanical. I spent a good bit of time yesterday afternoon prepping on this, and it took me, a while before I had to cross-reference all the different statutes. And I think this bill's certainly more complicated than the 2.5 pages that it's on. So can you kind of walk us through, or if it's somebody else is better situated for that?
And I will do my dead level best, but I will
Okay.
say that my familiarity with it is that I got it this morning and,
Aha.
and came up here.
So I'm ahead of you.
So you are ahead of
Yesterday,
me,
well,
although-
and if somebody that's joining us online is comfortable doing that, then that's perfectly
And if
fine.
not, I'll
with
make
me.
my best guess.
Okay, so why don't you walk us through and then we'll go from there.
Okay.
So,
First of all,
can you kind of scoot up a little bit
Yes,
to
can
pull
you-
the microphone towards you more? Just
Can
want to make
do.
sure that you're picking up online.
Can you hear me?
Yes,
better?
I
Okay,
can.
great. Thank you. All right. So I'm Rebecca Greist, and I'm the Solicitor General in Macon-Bibb County. So in Macon, so Jamie Borman is actually the Deputy Director of the Crisis Line and Safe House that I deal with about on a daily basis. And she is who sent the bill to me and asked me to come get involved, and I'm happy to do so. I'm also here on behalf of the Georgia Association of Solicitors General in support of this bill. Essentially, and I believe that Jamie is really the best prepared for this, speaking for doing all the speaking points. What I would like to talk to is just a few things that my prosecutors and I noted when we went through the bill this morning, and some suggestions. This might be a golden opportunity to fix some pretty minor things within the code dealing with stalking protective orders and family violence offenses. As long as we're addressing it, we can fix some inconsistencies that have been out there for a while. So that's where I'm coming from.
Okay, is it Borman?
Borman.
Okay, I need somebody to walk us through section 1, 2, and 3 with explicit details. I don't care who it is. Somebody walk us through and help us understand everything that is intended to be done with this bill.
I believe that is.
I can do it.
Thank you.
And I'm happy to do it.
You need to pull your microphone
Yeah.
down.
I'm happy to do it, Chairman. Thank you. And then if anyone wants to jump in on the call where I'm missing anything. So to just give you some context of how we wrote this bill, we looked at language in the 47 states that already have this in place.
So when you say, all right, so let's talk about that. And
Yeah.
and please don't take this as me interrupting you. I do my committee very conversationally. So 47 states, do the 47 states have a family violence classification for dating, or is it the protective order, which seems to have a little bit of a lower threshold to obtain a protective order than, say, the one under the stalking statute? That's kind of the two ways. I said, what is the 47 states representative of?
So the 47 states essentially recognize that the way that we do civil protective orders in court only include currently if you're married to the abuser or the accused, if you live with the abuser or the accused, or if you have a child with the abuser or the accused. It is just a gap, I think, probably because when we think about the context of family violence, the way in which relationships have occurred over time have probably changed, right? So there are probably more people who are in dating relationships that don't meet any of those criteria, but that are still in abusive relationships. And so it is expanding the definition of family violence to include dating relationships, and the language varies from state to state. So when we were thinking about the context of how we wanted to look at it in Georgia, we wanted to make sure that when we're thinking about a dating relationship, we mean an intimate dating relationship versus a casual acquaintanceship or relationships that might occur in a workplace or a social setting, right? So we took portions from different states to create the definition as throughout the entire bill. So for example, we want to acknowledge that there's a level of intimacy, but it does not have to be specific to a sexual relationship. So there are some states that do require a sexual relationship, but we understand that a sexual relationship does not define two people who are dating in an intimate partner relationship. And then the exclusion of the casual acquaintanceships between ordinary people in business or social or education context is to make sure that when we are thinking about intimate dating partner relationships, we're not extending it to something that wouldn't constitute dating. And I know that the language may appear to be vague, but that's where I think judge can speak on the way in which temporary protective orders work and the threshold that victims are required to prove in court as it pertains to establishing that relationship. In section 2, where we're talking about persons through whom a past or present pregnancy has developed, or persons in a past or present dating relationship. The pregnancy, I think, is easy to understand because under current law, if you are pregnant but you are not married or living with the person, you cannot seek a civil protective order as it pertains to family violence. The past relationship, there are some states who have put a timeline on how long ago that relationship had to have occurred. So we see variations of it had to be within the last 12 months or the last 6 months. The reason why we didn't put a specific timeline in Georgia, and some other states don't have that specific timeline with the past dating relationship, is because in family violence situations, we know there are situations where the accuser may be incarcerated and serving time for battery, and then they return back to the victim after they are released from incarceration. And so the time limit we felt would exclude people who were in those situations where there's a pattern that occurs through multiple years. And then in section 3, I think this is where the judge's discretion comes in, as it does with temporary protective order hearings, where they are going to include some of those factors of the dating relationship. So they'll look at the length and the patterns between the parties. And that's, I think, where judge from Fulton County would be able to speak more clearly on what that looks like in the court of law. The language was crafted by looking at other states, but also working in conjunction with the commissioner, as well as having multiple conversations with PAC, district attorneys, and people who actually practice in the court system so that it could be applied in a way that represents what happens in family violence court. And I think that if Jamie or Judge wants to jump in on just how it would play out in the court system and provide us with a better understanding of why those definitions are written in the way in which they are, that would be appropriate.
Sure. And so why don't Jamie, Ms. Borman, since you're on the screen right now, do you want to?
Sure. Yes, sir. Chairman Reeves and members of the committee, thank you for allowing me to speak to y'all via Zoom today. As Rebecca Grice said, my name is Jamie Borman. I'm the Deputy Director for Crisis Line and Safe House of Central Georgia, which is the Domestic Violence and Sexual Assault Advocacy Program in Macon. And I'm also a fellow of the Georgia Women's Policy Institute. I've worked in the domestic violence field for 15 years, and for 12 of those years, I've worked with victims of, or survivors who are seeking protective order remedies, or TPOs as they're often called. And I'm here today to ask you to support House Bill 231, which actually addresses a significant gap in protections for victims and survivors across our state. Currently, Georgia victims of abuse who are not married to, who don't live with, and don't have a child with their abuser don't have access to a family violence protective order. In my experience with working with victims, I've seen how devastating it is for survivors to hear that these remedies aren't available to them. just a couple of examples. I spoke with a survivor who was pregnant with her abuser's child and was seeking a protective order following an incident of physical violence. But because they didn't live together and they were not married, I had to tell her that she was ineligible for a protective order. I also spoke with a parent who was seeking a protective order on behalf of her 16-year-old child who had been assaulted by a boyfriend. And the parent was shocked to learn that her daughter didn't qualify for a protective order. The current law does not provide all victims of intimate partner violence with an avenue to seek a protective order. Research shows that protective orders are an effective tool to reduce the likelihood of future violence. And as they've mentioned, Georgia is one of only 3 states that doesn't extend that to dating violence victims. According to the Georgia Domestic Violence Fatality Review, 49% of victims who are killed by their abuser began the relationship between the ages of 13 and 24. And so without this change, victims in that age group are highly unlikely to qualify for a protective order. Victims need access to legal remedies sooner rather than later when experiencing violence in a relationship, not just once they're living with or married to or share children with their abuser. We want intimate partner violence victims to have tools to keep themselves safe before the violence escalates or before the relationship becomes long-term. And I think that House Bill 231 is a significant step in offering those protections. And to answer your question, I think that what this allows is just for the current family violence statute as it relates to protective orders to just be available to victims who are currently excluded because of the way that it's written. And the language that's been developed sort of closes the gap for those who aren't eligible at this time.
Let me go ahead and ask. Am I getting feedback? Okay. I think I'm getting some feedback. All right, let's give this a go. And let me just go ahead and say this administratively. You know, our job and our task on this committee is to ask hard questions and to really get to the bottom of things and take very seriously when we do things that essentially lessen a standard that someone would have to go through in order to obtain a restraining order, things like that. Those are very, very serious considerations, and we do right when we really analyze these. And it involves asking questions, and questioning some of those kind of things can be mischaracterized. And I think I speak for everybody on this committee, you know, that we have some hard questions to ask with this in order to make sure that we are getting to the issues that we need to look at on these policies. And one of the things that, you know, the way I understand what we are attempting to do here is to broaden the eligibility for a family violence TPO or TRO, however we're saying it. There is a pathway under Title 16590 under stalking that a person can obtain a TPO or TRO under current law. And so I think that one of the things that I want to make sure that I want us to be very careful with what we say. And if I'm wrong, then somebody educate me. But the way that I understand this is that there is a pathway under the stalking laws that a person can attempt to obtain a TPO or TRO. And so that when it said that there are some folks that are left without that option, which is what I've heard a couple of times, they may be without that option under the family violence route, but they potentially have a route under the stalking. And the way I see the big difference between the two, the way I see it, and I may be wrong, the family violence TPO requires one or more alleged violent conduct, and the stalking it says in 16-5-90 by establishing a pattern of harassing and intimidating behavior is one of the elements there. So one of the key differences, and if y'all disagree with me, then I want you to please tell me, because I very well may be wrong on this, but the way I see it, there is the option for a person to obtain a TPO under that would be in the dating scenario or the pregnant scenario. However, it would be under Title 16-5-90, and that would require a pattern, and that this is putting forth the ability to do that under Title 19, which would require one or more alleged event of violence or allegation of violence. Am I understanding that correct?
Yes.
Okay, so again, I am going to insist that everybody is held, you know, we're all held to the same standard here. There is a pathway currently for the folks that we're looking to add in here. There is a pathway. It's just it's the standard is a little bit different, and what this is it lessens that standard is the way I see it. Does anyone disagree with that?
Respectfully, Chairman Reeves, there is still a gap even with the availability of stalking protective orders, because in the two examples that I gave, for instance, in the instance where the woman was pregnant and had been assaulted by her partner, there was no pattern of behavior outside of acts of physical violence. So he wasn't placing her under surveillance. He wasn't following her. He wasn't texting her incessantly. The acts that would have qualified were acts of physical violence. And so she didn't fall under a stalking protective order because she couldn't establish that there was a pattern. And then with
let me interrupt you. By establishing a pattern of harassing and intimidating behavior, I just my read of that would be that violence would be, I could interpret that a violent act would be a harassing act or an intimidating behavior. And so other than the fact that the word pattern appears, which requires at least 2 incidents, that's how I'm seeing. I believe violence could be qualified as harassing and intimidating behavior. And if there's authority on that and I'm wrong, then again, I stand to be corrected. Yes. But what are your thoughts on that? My board here is lighting up, by the way.
Yeah.
So this is good. See,
And I'm happy to speak to it.
Sure, Ms. Greist.
Yes, and I will just tell you that the law actually treats stalking protective orders differently than it does family violence temporary protective orders. And that one of the things I wanted to bring up was under 16-595, what I would suggest is that we look at adding stalking protective orders to those protections of the 16-595, because again, the law treats stalking protective orders differently than family violence protective
And
orders.
I didn't understand. I think you just said add 16-595 to 16-595.
I'm sorry.
So,
Add stalking protective orders that are obtained under 16-594. And I think it's subsection C. I gave the language to Representative Gaines. So that might be one way of tackling it. But the problem is judges, in my experience and probably in Ms. Borman's experience, are not, you have to establish that repeated pattern of behavior. And they see it as a surveillance type of thing. It's how they are interpreting it. And that's why some of these victims are falling through the cracks, because not everyone who is in a, serious loving or skewed as loving relationship is living with their partner, nor are they getting each other pregnant. And kids, they may or may not be having sex. That should not be, but you have heard horror stories of 13, 14, 15-year-old girls who are being stalked by boyfriends, and that there is violence as well in these dating relationships with kids in middle school and high school, and we're not addressing that. And Ms. Borman, because of her federal grants, cannot assist in a protective order for a child under those circumstances, because they do not qualify as a family violence protective order. And again, judges interpret stalking behavior as different than the family violence behavior.
Okay, see, that's extremely helpful, and that's insightful, because I would, I don't know, when I think about something like this, I try to imagine myself behind the bench and hearing this out. And if somebody's making a case to me that, a stalking TPO is appropriate, I would personally think that harassing and intimidating behavior is broad enough that I could fit violence in that and get away with it. But every judge is different though, right?
Exactly. And so this kind of ensures that these people are protected
Mhm.
no matter what. And I think that's what they're getting to. And that's why we're saying, okay, just about every other state, all but 3 other states have this standard. We should be in line with all of those other states.
And so when we say that 47 other states have this standard, that is the standard of they have a concept of a family violence TPO, and that is extended to dating, relationship, and or pregnant
Yes. And
status.
understand, like in any prosecution, I mean, it's kind of our duty to look at it on a case by case basis. And Crisis Line and Safe House is going to bring people in. And if it's just casual and there's not really a nexus of a relationship, nobody's going to go take that in front of a judge. We have our reputations to protect as well. We're not going to bring something frivolous. And that's to kind of protect everybody else we've got to do behind it that really has a legitimate a complaint. And so, understand that this can be a case by case basis. We're not going to throw somebody who's been on 2 dates with somebody and it's very casual. That's just not the same thing.
And see, and I think that
is not.
That's the hardest, that's the hardest issue, I think, from at least where I sit right now,
Sure.
because I am forced sharing this issue. I got to look at this through the lens of how it could potentially be abused. And that's the concerns that I have. And what you just said very well may be the case for you and most other folks in your position, but there is always going to be the opportunity that this kind of thing could be abused, and somebody in your position may not see it that way. And can we prevent all of that kind of stuff from happening? No, but we do right by really getting in and having these discussions now, because it's certainly, we're all aware of cases where somebody's been charged with a crime based on a false accusation.
Right.
I've prosecuted cases where it's come to my attention, and it's one of the most shocking and upsetting things that you experience as a prosecutor when you commence a prosecution based on a lie. It is absolutely one of the worst situations you'll ever face. And I've defended people who are falsely accused. And our job is to look at this, and we have to look at it 360 degrees. And that's one of the issues that I'm concerned with, is the potential that does it loosen a standard that makes it more ripe for abuse? And I don't know the answer to that question. That's why we're in this committee, is to talk about this and go all the way around the circle on it. I'm going to go around the committee now. Chairman Setzler.
Thank you, Mr. Chairman. Appreciate the presentation and the discussion. We're going to ask the hard questions. I spoke to the author yesterday and said, hey, let's look at this. Let's understand the things you're trying to accomplish. Let's look at them distinctly, and let's explore what I would call the boundary conditions. What are those circumstances as the definitions go? That was really the basis of our discussion. I've heard a lot of discussion about pregnancy. I think the most persuasive circumstances are around a couple that has the mom's pregnant, they're not living together, and there's no ability to get a family TPO. I think that is its own. It's a circumstance. I think the dating relationship, as is explored here, is a very different circumstance. I would say, as we talk about pregnancy or past pregnancy, I think we need to explore the past pregnancy. What does that mean? Because there could be no ongoing relationship. There's no ongoing pregnancy. You've not got a mom that's carrying a child that has this relationship with the dad. I think so. We just need to, as we unpack this logic table, you have a pregnancy, a past pregnancy, and then the dating relationship, Mr. Chairman, that's highlighted here. My concern to the author and to others around the dating relationship definition means romantic or intimate social relationship. So there's no requirement for a romantic relationship. No defining what's romantic, what's platonic. That's a nebulous question that many of us have explored on our own lives before, right? But what we're talking about here is I mean, again, as we explore the boundary conditions, we're talking about close friendships, intimacy or knowledge or affection not associated with casual acquaintanceships or associated with persons of ordinary business, social, or educational context. So it's a friendship that's different than somebody that sits next to you in class. It's a friendship that's different than somebody who sits next to you in the next cubicle at work, or an ordinary social interaction, someone that you went to high school with, and just made. So as we unpack this, I think we really need to explore the definition of dating relationship and what that means. I'm concerned that we need to ask ourselves the question: is it an appropriate policy approach to say people who are friends or dating should a family TPO be a mechanism that's used there or not? That's a policy question. I'm not there yet. Perhaps I can be there. But if we're going to go there, we do have to still answer the question: is this definition the right definition of what we mean by that? And there may be some things we'd love to apply to, but to have a solid test, we've got to have solid definitions. As I read this, and I'm not doing it to be absurd.
Yeah.
You know, we debate ideas, we talk about ideas, but we vote words on the page. My concern is, and I'm not stretching it, it's the plain reading of the definition, is an intimate social relationship that's not romantic, that has a level of knowledge, affection, or intimacy. Not all of those, but one of those. So someone I know very well and have a good friendship with, same sex, different sex. If there's a breach in our relationship, I can go get a family TPO against them based on this definition. Now, we can say that, oh, the judge wouldn't do that. That's not what this is about. I get that. But I'm saying as we unpack this, we've got to tighten I think we've got to tighten this definition, because me and my best buddy, my guy who lives down the street with me, high school friend, I don't know that my high school friends ought to be able to get a family TPO against me, because he knows a lot about me. We know a lot about each other. And I don't. So I think the definitions need a lot of work.
Yeah.
And I think we also need to, Mr. Chairman, ask the question: is a relationship that's a friendship at whatever level, should the family TPO that is dependent on these important statuses, one of which I agree with, I have to be added, is a mutual pregnancy. Is that level, why has friendship been held out of that? Okay. I would also say, parenthetically, I would question that all 47 states have this structure, Mr. Chairman. The pregnancy piece may be in 47 states. I don't know that this exact structure is there. So we need to explore that. And those are just my concerns.
Yeah.
I'm going to call on Chairman Abstration.
Well, thank you, Mr. Chairman. I've read the bill for the first time here today, admittedly, but I do quite a few TPO hearings. I'm very familiar with the process professionally, not personally. And I'll just say, I think this bill is incredibly well written as I read it. So when I read the classification, let me back up by saying this. I'm very familiar with circumstances where parties go to the courthouse and they are unable to proceed with a petition because they don't meet that relationship requirement. And the predicate requirement for a stalking TPO, you've correctly outlined with the pattern, but ultimately, if you have a circumstance of family violence, which could include threats of violence that are made, could include specific instances of violence or other conduct which outside of the context of family violence might not be considered to be maybe red flag behavior, those parties are just immediately dismissed because they don't meet the classification requirement for consideration going forward. And this addresses it, and I think the best possible way that you could. And so by outlining romantic or intimate social relationship, I mean, how can you completely identify romantic relationships in the law?
And that's the challenge.
And my view is this gets right up to it, because in the hypothetical that's been referenced, I don't think that what was explained would, in other words, someone who knows a lot about me would meet the criteria. I'm happy to go through it, but just to make sure that there's no issue, you have in Section 3 where the court must find these two additional elements, which again it's even beyond even a casual acquaintance. It's and in a lot of ways, I think really heightens the nature of the relationship. The final thing I'll mention is this, we trust our judges who see these types of cases every day in court to make the right decision. And is it conceivable that someone could come to court and fabricate a relationship? Sure. But they could also fabricate that they've previously lived with the other party. They could also fabricate that they've, other aspects of the relationship. And it seems to me that this bill and this language captures a real need that we have out there right now and does it in a way, as I read it sitting here, the most effective way possible. I'm certainly interested in any amendments or recommendations for different language, but I just believe, I want to commend the sponsors for their work on this, because it's clear to me that you're really zoning in on the area where work is needed. And finally, I'll also mention, as far as the relationship of the other person, that predicate offense also in these is an incident of violence. And as you all maybe are aware, if you've done these petitions, at least in my court, also the criteria for consideration includes mental health, substance abuse issues by the other party, suicide attempts, whether or not there are other extraordinary considerations that must be given under the circumstances. And by simply having a predicate element of a lack of relationship where those cases are dismissed, you leave a huge gap. And finally, I would just commend to the committee, if you do believe that the language should be changed, then let's talk about what those changes are. And I want to thank the sponsor, Representative Wynn, the advocates who are online, and Solicitor Grist. Thank you.
Okay, and what I'm going to try to do is very quickly take Representative Bodie and Lopez have their lights up, and then I'm going to run out of time. And what I can do is I can push my Boy Scout meeting that I have at 7 o'clock. I can ask to push that a little bit later, so that, because Representative Holcomb has been here and I do want to give him the chance to go through his bill. We can keep talking about this for a few more minutes. What we're going to do on this bill is I'm going to hold this bill right now, and we're going to come back and have another hearing on it. And we'll discuss all the things we're talking about, whether or not there is, I don't have a preconceived position on if there is language that would be better, then that's something that I want us to consider. What my goal is to dissect this thing and kind of take it apart and then put it back together. And I think that's what we're doing right now. So Representative Bodie.
Thank you so much, Mr. Chair. And I want to kind of piggyback on what Chairman Chuck Epstration just stated. I've definitely bumped into him in the Gwinnett County Courthouse a couple of times, so he definitely knows of what he speaks, and he's absolutely correct. This is the issue that we need to address. In my practice as well, I've dealt with TPOs, both defending them and also trying to get them issued. I see this a lot in situations with younger couples, and if we don't have this statute and listed as family violence protective order, we need to have something that encapsulate this language, because this is too important. And I've had clients as well cannot get the TPO because they're not married to the individual. And it's been a situation where violence has occurred after a case has been dismissed by a judge. So I would say this is very important. And I would also want to say that under Section 3, Section 3 and subsection 1, the language itself, when it says over and above that of a mere casual acquaintance, I think that covers exactly the issue that you have, Mr. Chair. And also,
well, and to caveat that though, the first part of that sentence says there is minimal.
Yes.
So that actually, the first part of it actually takes away from what over, and that was one of the issues that I wanted to raise is the word minimal. Again, I don't have an opinion one way or the other, but I think it's something that I would like for this committee to talk about is what does the word minimal being where it is in this, how does that impact the possibility of, our job is to look at this and how it can be abused. And does that word minimal exacerbate the opportunity for abuse on this or not. And it very well may not. That's why, that's what this committee is doing right now is we're looking at that.
Mr. Chair, I think we should strike the word minimal. I don't even think it's needed there. It's we're just looking at statutory interpretation and structure. It does negate the second portion of the code section. And so that particular line section. So I think we struck that word and we just go forward with social interpersonal bonding of the parties over and beyond, over and above that a mere casual acquaintance or ordinary fraternization, you're covered. I just think we need to just take that word out because it's doing exactly what you said. It's negating the second portion of the statute line itself.
Yeah. What I'm going to do right now is I want Judge Manning. I know that Judge Manning has been patient on our hearing here. And Judge, I would love for you to give your 2 cents on things right now.
Okay, so thank you very much, Mr. Chairman and everyone. So in Fulton County, so I'm here because in Fulton County, Monday through Friday, I sit as a Superior Court judge. And well, Ms. Perez isn't on here, or Mr. Carrera, but so I hear, especially during the pandemic, I've been hearing DB cases 5 days a week. So since March until, March until about August, I had a total of 1,000 DB cases. Now, I know that a lot of people think that, okay, DB judges, they hand out TPOs like candy. So restraining order is completely different from a protective order. Restraining orders, you go to magistrate court to get a restraining order. So a protective order, it's really easy. Right now, you could go down to the courthouse and tell somebody that, Alex Manning's following you and sitting outside of your house, and you'd get an ex parte stalking order. True, you would get that automatically. But I think I've seen enough and I've heard enough, and all of this is an element to a case. You're going to have to prove that you went out on a date. But what's a date? Were you on a date? For example, were you on a dating app? Did you swipe left or swipe right or whatever you do on a dating app? So did you go out twice? Is that dating? Maybe. Did you pay for dinner? Well, that's just another element that you're going to have to prove. People have to prove that they've been living together. I mean, it's another element that you have to prove. And I think most judges that have done DV court they can prove that. If that had, on a typical day without a pandemic, on Mondays and Fridays, my courtroom probably had over 50 or 60 cases on a Friday. And when I would hear them, I know exactly what I need to hear. And I would typically dismiss more than I would issue and continue them for 12 months. So I think that everybody would get treated fairly. And some of the people that did suffer would be people in college that would date, or a lot of high school kids that were dating, and there would be abuse in dating. Or they break up for what it's worth, and they would stalking and they're texting each other and calling each other, won't leave everybody alone. So, but people that can't go under the Family Violence Act would go under stalking, and I would have to turn it down because they're not stalking. They maybe slapped them or abused them, and that's it. And I can't grant it. I mean, they get the temporary ex parte relief maybe because they said, okay, they're calling me a few times, but then that's it. I can't grant it. And this is a hole that needs to be plugged for people that are dating. It really is. You would be amazed, especially in younger folks and teenagers in high school, how much abuse goes on, and they need to be protected. And I do know that probably, and if Ms. Perez was on here, she could correct me, at least in the last year, a calendar year, I know of 4 people that were killed. And if you think that things I did things to and prosecuted wrong, people that haven't done anything and defended people that haven't done anything, but sitting in domestic violence court and getting a call a week or 2 later, or seeing it on the news and seeing that somebody that's been in front of me, whether I dismissed a case or put one in place, got killed, I've lost a lot of sleep in the last year or so. That is something that really tears me up. And some of this is something that I can't do anything with. I think something needs to be put in place, and I think it's a little judge's discretion to decide and make that determination. What is dating? And I think if you meet on a dating app, you're not friends. You're dating, you're going out. That's for the purpose of being closer than friends.
Judge Manning, is there case law that establishes that physical violence is not harassing or intimidating behavior under the stalking statute?
Yeah, because it says he or she follows, places under surveillance, contacts another person, at or about a place or places without the consent of the other person for the purpose of harassing, intimidating the other person and putting them in fear. It's not just popping them or slapping them one time. That's what stalking is, when you place somebody in under surveillance.
Right. And I know I'm familiar with this surveillance language that, and I'm referencing the latter part of A1 in 16590, where harassing and intimidating means a knowing and willful course of conduct, et cetera. And then comma, by establishing a pattern of harassing and intimidating behavior. But so, and it's really beside the point of what we're dealing with. But I guess what I was curious is there case law, is there authority that establishes that violence doesn't get us to that threshold?
Not that I haven't really seen any, because you got everything that I have of the different cases is you can cause emotional distress, reasonable fear. I mean, if they can get out there and articulate things that give them reasonable fear, and the behavior that they have is intimidating and, you know, serves no legitimate purpose. If there's a course of conduct, psychic or emotional harm, threats, if they keep threatening things and it puts them that way. Yes, but usually when they're doing things and it's family violence, it's not that it's a pattern. It's they may do something 3 months ago and then 6. So it's not that pattern of, you know, 75 phone calls or showing up at their work and doing that same thing. It's not that much of, it's not the same pattern as it is when you're stalking. If that kind of makes sense.
No, that does make sense. And, you know, again, that's the way the difference that I look at these two options. I know that I'm simplifying a little bit, but the pattern versus one or more, those are, to me, is the material difference between the two routes. But I think this hearing has been productive because I'm seeing this more clearly than I was when we started.
And it's not just the one or more, it's the pattern too. It's not just the number, it is the pattern of what they're doing.
All right. Thank you, Judge Manning. That was very, very helpful and insightful. What I'm going to do now, does the author, we're not going to call a vote on this today. We're going to sleep on this, look at it, look at these definitions. I am curious about the 47 states and kind of what that looks like and the definition of dating. I think that for me, the way that I think that it's worth our effort to attempt to try to get as close to the line of perfect as we can possibly get to on this is to analyze whether or not we've defined dating relationship as well as we possibly can. And then I do also want to look at the word minimal on line 49 and consider removing that. And so with that, we will work on those things, and you and I will talk, and then we'll bring this back before the subcommittee. So we'll move on now. And Representative, thank you, everybody. That was that was exactly what I hoped would happen in this subcommittee on that issue. So we're going to move on now. Representative Holcomb has got a substitute. The substitute is LC 280080S. Okay, Representative Holcomb, what I want you to do is I want you to walk through and give us a 30,000 foot. Well, tell us what you're doing in general, then give us a 30,000 foot for each section, and then we will we'll go from there. And you don't have anybody that is specifically speaking on behalf of this, do you?
I think the only one is Ms. Travis may have some comments.
Okay. All right. Floor is yours.
Okay. Thank you, Mr. Chairman, members of the committee. You may recognize this legislation. This legislation came through last year, and it was attached to House Bill 720, which made it to a floor vote. The basic backdrop of it is, you all know that our state has done a lot of work to address issues of sexual assault over the last 5 years or so. We've done on a very bipartisan, inclusive basis. I serve on the state's expert committee that continues to look at these issues year round. We get together, we collaborate. And so what this bill reflects are those items that we thought were both important and also largely agreeable to most constituencies. So I'll walk you through what the bill does. In Section 2, the purpose of this is each jurisdiction is supposed to have a sexual assault protocol. Not everybody's doing it. So what this would do would be to just have a reporting requirement. So that way we would know which jurisdictions are not following the requirement to have a protocol. And
when you say
and we could
jurisdiction,
address
what do you
that.
mean?
I mean the county jurisdiction and the district attorney. By law, it's all set up of who serves on the sexual assault protocol development. And we just have jurisdictions that are non-compliant. So the idea behind this is to have a reporting requirement so that way jurisdictions would be compliant. And it's actually judicial circuits. I misspoke in line 39.
That's what so you mean judicial circuits. Okay.
Yes.
So is there anything, what I take it there's nothing statutory that requires them to do this now?
Exactly.
Okay. And that's what changed that.
Correct. All right. So Section 3 is just a change in language. The language that we had, and this was consistent with the old way of looking at this, was if the victim does not cooperate with law enforcement. That certainly connotes a negative view towards the survivors of sexual violence. So we would change that language to if the victim chooses not to immediately report, as is the victim's right, which reflects how things stand under the law, both in Georgia and also federally. Section 4 is probably the real meat of the bill. And what this would do, we've been working on this for a long time. This would set up a sexual assault tracking system. So when there is a victim of sexual assault and a sexual assault kit is taken either at a crisis center or at a hospital, from that point forward, we would have a system to track it. And it would be controlled in terms of privacy, but the victim would know when it was sent, the kit was sent to GBI. The victim would know when the kit was tested, and the victim would also be alerted when there are updates in terms of matching to DNA. So it is a process by which we can have greater transparency, by which as a General Assembly, we can track the flow rate of how long it's taking these kits to be tested, because we've spent a lot of money and invested a lot of money to address this. So it's a very, I think, smart and appropriate reform that builds upon the work that we've been doing.
Would it be an appropriation to fund the CJCC to be able to implement this?
Right now, there are grant fundings for it. It is possible down the road that it could be an appropriation, but the monies that we're talking about are relatively small. They're 5-figure numbers. So it would not be huge at all, but right now there are grant dollars. I can't go so far as to say there will always be grant dollars available, but what I can tell you is that many of the grants in this space for sexual assault are renewable on an annual basis. Okay, so Section 5, this section, in both Section 4 and Section 5, if approved, would put Georgia really on the vanguard of dealing with these issues nationally. This section would have coordination between Georgia law enforcement and the Federal Bureau of Investigation's Violent Criminal Apprehension Program, also known as VICAP for short. These are the worst of the worst cases. These are the serial offender cases. These are the mass murder cases. These are the Samuel Little cases. We worked, or I worked in coordination with the FBI on the language, and it would very simply just set a coordination process in place for our law enforcement to provide information for a very discrete set of crimes, and those are listed in lines 124 through 131, for which we would put this information into a database with the goal of capturing individuals and for these types of really heinous and horrific crimes. Moving on to section 6. This addition was a recent addition this year, and what I would propose the committee do would be to, for now, remove this section from the bill. I'll tell you what it does, and what it does is it sets forth an overall review of sexual assault nurse examiners. Our state needs more sexual assault nurse examiners across the state, but some concerns have been raised to me, and so I think the best way to deal with that is take it out of this bill and file it as separate legislation. So I would commend to the committee to just for now take section 6 out of the bill as we continue to move forward. And then sections 7 through 9 are to address what thankfully is a very rare occurrence, but it is a very significant occurrence. And it is when a physician sexually assaults a patient. Under the former rules, what would happen is a doctor would be sent for counseling. I don't think that's good enough. And I think that there is a real change within medical communities to recognize that that's not good enough. I coordinated with the Medical Association of Georgia on this bill. I've actually been working on this part of the language for a number of years. And what this would do really simply is if 3 things happen, and these are in section 7, if the medical board finds after conducting an investigation that a doctor committed a sexual assault, or if the doctor pleaded guilty to committing sexual assault on a patient, or has been found guilty by a court of sexual assault on a patient, then the board has to take some action. It needs to either suspend or revoke the license. And then there's also a reporting requirement to the General Assembly as well. And that's in section 9. So that way we can kind of track to see how often and how widespread this is. Again, thankfully, based on what we know now, it is very rare, but it does happen, and it is a gross violation of the doctor-patient privilege, and I think that there needs to be some action that is taken, either a suspension or revocation under these circumstances. So that's kind of a broad, high-level view. I'm happy to answer any specific questions that y'all may have.
Where's MAG on the section 7 and 8? What kind of cooperation or support do you have from MAG on
They are
this?
supportive.
Are they supportive with the language as is, or are y'all still working through that?
Nope, they are supportive with the language as is.
Okay, I'm going to go to number 1. I think that's Montahan.
Thank you, Mr. Chairman. Representative Holcomb, quick question. As we read through section 7, if we have a physician who has committed a sexual assault, why are we only revoking a license if he's done that with a patient? What was it? I mean, I feel like if you have a physician who's committed a sexual assault, we probably don't want him. I mean, being a doctor. I don't know if that's me. I mean,
well, that's a great question, and I think that's the point of what this is trying to prompt. And we built in the flexibility of suspend or revoke. It's difficult for me to think of any extenuating circumstances where suspension may be the appropriate remedy, but they have to do one of those 2 things. They have to suspend or revoke. And certainly if it was, well, 2 of the criteria are pleaded guilty, which means that the physician would have had to say under oath in court, I did this and I accept the punishment for it, or a jury were to find sexual assault of a patient. And just to highlight, this is only for patients, so it's that very strict relationship aspect. But yeah, I think that it's an appropriate remedy to put into the law for the protection of the public, because as I started with, what had been done was they were just sent to counseling. And we didn't know this. We didn't know who had these allegations against them. And I'm not going to the lower level of just an allegation. I'm going to a much higher standard of you have to plead guilty or be found
that's
guilty
right.
or a board.
Let me kind of drill down a little bit. My question really wasn't about that. It's really about if we have a physician who has committed sexual assault while they're practicing medicine, should it matter if it was with a patient or anybody else?
Well, it's certainly a crime. And so what I would like to see is certainly more cases of sexual assault prosecuted. We have very, very low rates of prosecution. I think that's probably a bigger issue than what I'm trying to tackle here, but you won't get disagreement from me of should people that commit sexual assault be held accountable? Yeah, they should.
Right. And I think that's what I was trying to get to, because if we read this, it says a physician who just take out on a patient. I mean, I don't know. That's just food for thought. And I know we're just talking about this issue, but you know, I wouldn't want a doctor, you know, I've got 2 daughters. I wouldn't want a doctor who's been convicted while practicing medicine of a sexual assault to be working as a pediatrician, right? I mean,
Yeah.
I really don't care what type of it was. I just, food for thought.
Chairman Setzler.
Hey, Mr. Chairman, I appreciate the bill to the author. One thing I wanted to share as a consideration is 16.6 5.1 is improper sexual contact by employee, agent, foster parent consent. It talks about sexual contact between an employee in a hospital or a medical environment. I think it contemplates hospital here, but there's other licensed facilities under sensitive care facility under Title 31. So there's a whole series of those. I need to go back and double check those cross references, but the issue of inappropriate sexual contact has been fleshed out in 16.6 5.1 over a number of sessions. Chairman of Administration, formerly chairman of this committee, remembers the pain at which we address that. So that may be something that can be referenced, or even if it's unclear that any contact between a doctor and a patient that's inappropriate, that section is teed up for that. And based on the nature of the contact, whether it's that which would be a battery, a sexual battery versus an aggravated battery, there's sort of a line there we drew about the explicitness of the conduct. It creates a framework there that even if it were quote otherwise consensual, still becomes a crime because of the relationship. So if there were a patient in a medical setting that was accepting in advance of a doctor, but a doctor followed through on sexual contact, the consent's not a defense because of the nature of the setting. So, you know, I appreciate what you're doing in 7 and 8, and that may be a place to look at that already kind of has a framework around which consent's not a defense and medical environments are invoked. So thank you for the bill.
Thank you.
I'm going to ask Ms. Travis. She had indicated to me that she has a couple of minutes that she wants to talk, and then we're going to adjourn. We're going to take a harder look at this and continue the conversation on this, Representative Holcomb. But Ms. Travis.
Thank you so much, Mr. Chairman. I'll be brief. Focusing on Section 7, the difficulty that we're having is, of course, our members would be defending the doctor potentially for these licensing decisions. And it's clear that the doctor has committed what? A sexual assault. What is a sexual assault? That's the problem. Sexual assault is not defined anywhere here. If you look at line 214, sexual assault is defined in 1524.1. All we're saying is we want to be on notice as to what it is that's going to cause the doctor to lose their license. Actually, to Representative Montham's point, is like we need to know what it is that the charge is. So if we'd ask for sexual assault to be just defined there. And then on Section 9 of the bill on page 10, if you look at line 231 and 232, it directs the reader to look at paragraph 15A of 4334A for a definition. And we all know that usually when we talk about definitions, we say this means X, but when you actually look at the cross-reference, the language that's there is just says committed an act of sexual abuse, misconduct, or exploitation of a patient, including guardians and parents of minors. It doesn't tell us any meaning. So I think that the cross-reference isn't explicit. And then lastly, with regard to section, the VICAM section 35-123, where you're dealing with the federal government and reporting up through the feds of people's names that have committed crimes, serial rapists, that kind of thing, serial murderers. And, you know, sometimes you have the names of the perpetrators. If you look at line 132, the name and the date of the alleged perpetrator, we all know that sometimes people get it wrong. And there's no mechanism in this section for law enforcement to correct the misinformation. So they have the wrong date of birth, they have the wrong person. So we're just looking for it to be taken off the law enforcement federal list when it is not accurate. That's it. Thank you.
Thank you, Ms. Travis. Does anybody else on the committee have anything to add at this point on Representative Holcomb's bill? Okay, great. We'll be in discussions about this and the things that she raised. Maybe perhaps y'all talk and work with legislative counsel, and then we will discuss. All right.